Good afternoon, Patriots, and welcome to the 60-second audio chat on the Q News Patriot Rumble channel series. I am the Q News Patriot, joined today by a very special guest. My name is SG Anon. My guest today is a truth seeker, a self-described trust expert, having been involved in extraordinarily high levels of wealth management and estate management, and a patriot for the people in the truest sense possible. Mr. Todd has a background that is uniquely qualified to offer an interpretive lens and a bit of a mentoring attitude towards this idea of jurisdiction, personal jurisdiction, sovereign jurisdiction, terminologies that are coming back to the fore in a way worldwide that we've really not seen all it simultaneously for a very long time, if ever. It's very interesting how the linguistics along in this journey have been warped against us, how we've been self-describing ourselves in this way or that way, and the sleight of hand warfare tactics that have been deployed against us, not only in the mental and emotional landscape, but also in the legal landscape, are truly impressive and truly deep. Todd has spent a great deal of his life exposed to those types of subtle differences, and again, has a unique perspective and lens to offer, and I'm very glad to bring him on. Todd, thank you for joining me.
Yes, thank you for having me today. So with that, I'd like to actually start, I guess, with a little bit of introduction when we're talking about all these different legal words that are put in front of you. And I just thought of this as we were talking before we started the show, and the way that we present ourselves to the government and present ourselves to the courts. I would like to actually do my introduction that I put in all of my court pleadings and filings to make a very firm point to the court of who and what I am to the court and what my standing is under the jurisdiction that you're entering into the equity admiralty courts. So my typical introduction will state like this. It'll say, now comes aggrieved party with the right to a remedy. Todd Duell, UCC 1-201, section 1, 2, and 3, 27 and 14. Hereinafter aggrieved party, sui juris, secured party, UCC 9-105, non-person, UCC 1-201, section 27, non-resident, non-debtor, 28 USC 3002, section 4, non-corporated, non-fiction, non-subject, non-participant in any government programs, a living flesh and blood man standing on the ground, sovereign non-citizen under special appearance rule 8E, not generally, non-defendant, UCC 1-201, section 14, holder in due course, UCC 3-302, section A2 of all documents, UCC 5-102, section 6 of the entity Sesta K Vi Trust corporate fiction Todd Duell, representing the corporate fiction. The Treasury Direct account is now stated as, and then I have my numbers for my account, is open and all records are publicly available for the Secretary of State for review. Under no circumstances is the defendant pro se, as this complaint is filed under the holder in due course, Todd Allen Duell of the Sesta K Vi Trust of Todd Allen Duell. Bonds are deposited with the clerk of the court, UC 28 USC 2041, to adjust the account, set off, settle, and discharge all private and public liabilities in accord with public policy. Okay, so that's my typical introduction that goes in all my court pleadings to correct my standing with the court. Because when you walk into a court, their presumption is that you are assumptive, meaning that you are the debtor and you are a minor, and that you are there to be one and the same as your corporate fiction, and your only job is to pay, either by going to jail or pay with money if it's a commercial claim. They do not want you to understand that you have access to your acquittance and discharge account. So that's kind of a mouthful there, isn't it?
Well, I was about to say that's a remarkably powerful introduction, and I want to come back to some of those finer details here in just a moment with some of the documentation that you sent me. I showed a little bit of it in a moment ago to follow along with your introduction. But what struck me so significantly when you and I connected, and with respect to the projects that you've been working on, is the technical mastery of the skill set. You know, you have a very high level exposure to estates, to trust law, and operating in the true private versus operating in the exposed jurisdiction, right? And also the fact that there are different jurisdictions. And so, one of the things I'd love for you to do, if you
Well,
don't care, is
yeah,
to give.
actually, everything is a jurisdiction, and you have to address it. And part of the problem is why there's so many jurisdictions is we have a blended law form jurisdiction in the courts. The courts are literally common law, equity, admiralty, and maritime, all blended into one, what they'll claim is statutory jurisdiction or civil law. That's Federal Rule Civil Procedure Rule 12B2 or 12 Rule 2, sorry. Federal Rule Civil Procedure Rule 2. And that's part of the problem is the blending of the law form jurisdictions is there's so much junk going on inside the courtroom you have no idea what they're actually throwing at you, and it's very difficult to ascertain what the true nature of the court is.
Well, with that in mind, do you care to give me a quick Reader's Digest summary of how you came to this information and how you were able to ascertain it?
I mean, my dad was also a judge and law school professor, so we kind of grew up talking about this stuff at the dinner table, so it was very common knowledge around our household. And then once you enter into the trust world and you start doing commerce with commercial paper and securities, you learn that what's actually running the entire system is the Uniform Commercial Code, because everything's a contract and everything's commerce at its core. So your bar attorneys typically will understand case law, and that's about it. And they'll understand like somebody has to pay and somebody has to perform. But once you start stepping into the UCC realm where the actual banking and commerce is happening, they don't have a clue what's going on. They're also procedurally barred by the Bar Association from even exposing to you that there's two entities. There's you as the natural person or the living man or woman, and then there's your corporate fiction that they believe they own and operate and control because you turned it over to them. And your common law trustee is actually we understand where the common law trustee is because we hunted this down decades ago. The common law trustee for your estate, for your fiction that they're controlling, is actually started at 40 statutes at large 411 section 7e, where you covered your birth certificate securities under the Maternity Act of 1921 to give them control over your legal fiction. Now, that account is also supposed to be used for you for discharging any commercial liabilities that come your way, whether it's like IRS taxes, court cases, anything. But they don't want to give you access to that account because they need that to fund themselves. But later in the late 2000s, they actually transferred the administration of the custodian to the United States Attorney General, who's currently Merrick Garland. That's 50 USC 4312. So the issue that we run into these days is you've got a trustee for your estate. And if you, for example, try to do something basic for them, like send them a bill and ask your trustee to pay it, because trustees pay your bills for you in a general sense in the trust realm, they'll completely ignore you and they won't handle your commercial transactions for you. They won't actually help you at all, which is why we've gone down the route for the last 25 plus years of doing a process called revoking and revesting legal and equitable title under the merger rule for trust law, where we're firing our trustees and saying you're incompetent and you're intentionally injuring us, so we're going to collapse the entire estate and take it over. So we're going to collapse legal and equitable title and take over the whole estate and wipe out their ability to have jurisdiction over us, our estate, or over us as a natural person. And that's actually Federal Rule Civil Procedure Rule 12B2, no personal jurisdiction. And so that's the one that a lot of the states actually try to take out of their statutes and claim that they don't have to comply with that federal statute for defenses for jurisdiction. But there are ways around that as well. But they've taken proactive steps to try to do their best to claim that you are one and the same as your fiction and you're responsible for all civil and criminal penalties, even if there's no injured party. It's the whole system is actually just a shambles at this point, and it's coming down very quickly at this point, to the point where we're on scorched earth policy and we're going after everybody's bonds.
You bring up an interesting conflation of jurisdictional concepts here. The idea of the personhood, the human being, the living man, the flesh and blood and bone breathing individual standing upon the ground and not upon the water. And then this corporate fictitious statute, which you've described as sort of an estate that they create out of your living personhood. If that's an
Yes.
inaccurate description, please correct me.
Yes. Yeah, and the correct way to describe your fiction is, don't call it, sovereign citizen. Don't call it technically the correct word is ens legis, or item sonens or nom de jure. Those are technically correct, but call it your estate, right? If you want to look competent in the legal world, please call it your estate. Okay. And then inside your estate is your trust, right? That is your minor account at the Treasury Department. You can find that at 31 CFR 363.6. So you have an estate, which is your fiction, and you have a trust in there, which has unlimited credit attached to it. Right. And so that gives you the unlimited ability to discharge any liability using the proper IRS procedures.
So it really is a reclamation of your own personal jurisdiction over your own personal estate.
Yeah, and the problem is you always have to ask the basic question in this scenario is who has legal title, management, or ownership over my estate? Until you become a secured party creditor holder in due course and you revoke and revest legal and equitable title, the government, essentially, Mr. Garland, is your common law trustee and alien property custodian. So they have 100% control over your estate, and they'll do everything in their power to wreck you, right? Because they are on the attack, basically, and have been for quite some time. And so until you go through this process and put them in their place very quickly and start filing tort claims against them, they're going to continue to attack you because they believe that you are the debtor and that you owe the United States. And it's absolutely untrue. There's so much case law from Guaranty Trust versus Henwood and Perry versus United States when all of this stuff went down, where when this first started, the Supreme Court and the government said, no, the people are sovereign to make the laws and to write the constitutions and to put the government in its box. And because we hypothecated and rehypothecated the debt that's owed to the foreign creditors, the people are still the primary creditors. Okay, that's the difference. You have to understand debtor-creditor relationship, not necessarily sovereignty. Sovereignty is well understood all the way back to Chisholm versus Georgia. So the government does know that the people are the sovereigns, that they ultimately make the laws and they have control over it, which, on a different discussion, maybe if we were at a meeting where we talked about like jury nullification, where you can actually strike down bad corporate statutes and policies, that's an ultimate remedy inside the courtroom if people understand that they can strike down corporate policies in the courtroom. And they've covered that one up pretty well in since the 1950s. So there is remedy out there, and everybody needs to learn how to enact it. And I've actually had a couple of jury pools that I've had completely thrown out because I enacted remedy in the courtroom as a juror.
Absolutely remarkable. And I think speaks to a skill set that no one has really been clued in on, certainly not educated on in any sense for a very, very long time, maybe if ever, since the installation of this corporate fiction over our great republic. You sent to me some documents that I hope you're okay with me continuing to share here. I pulled a little bit from it a moment ago, but it is
Yes.
a tort claim that has been filed on behalf of yourself in San Diego County Superior Court. And I found the document very compelling. And if you don't mind, considering the technical mastery that you have over this subject, and we could get into that, but I think it would, be fundamentally a waste of my audience's time to pedigree all of that out. But I would really appreciate if you could give us some highlights. Let me come over here and share this screen of a couple of things that are sort of universally applicable and important for people to know.
Yes. So if we go over it at a very high level, I'm not going to get it into like, crazy detail or anything, because most of you aren't prepared to go to that level at this stage. But let's just say that there was a bogus criminal charge filed against me, which wasn't. It turned out they ended up dropping the case anyways, because it turned out that they made some massive mistakes. But they did hold me in custody for 3 years and wouldn't let me out and claim COVID. The courts were shut down, and I kind of looked at the and I won't even call them a judge. They're actually case trustees. So let's just cut to the chase. I looked at the trustee and I said, "You understand this is going to end up really bad for you, because this is going to go to your bonding and underwriting, because you're kidnapping me and you're holding me against my will, and it's false imprisonment, because I've actually already discharged the case. I've already put in a bond to discharge the commercial liabilities. So at this point, under case law, you actually have to let me go, and then we can adjudicate the claims to the alleged creditor, which is allegedly the state of California, who's operating as a fiction as part of the United States. So you guys are traversing all over the place and don't know what you're doing, and it's going to cost you in the end." And so, as we had talked before, it kind of got to the point in the process where literally they tried to kill me over this. So part of their game, when you do the discharge process correctly like this, and for everybody's knowledge, what he's showing you in front of you is not a new process. This is 77 years old. This process was actually developed by very intelligent federal judges, international judges at the international court, and attorneys, and it's been the process for 77 years. To deal with discharging of a commercial case. So at the core, everybody needs to understand that we don't have criminal cases in the United States because of the blending of the law form jurisdictions. The only time you really have a true criminal case is if it's murder, rape, arson, child abuse. Those ones, technically, we're not even allowed to discharge, even though they're still charging a fiction under the current judicial platforms that we're running in the administrative courts. We're not allowed to discharge those. We still have rules for that too. So the core is, when you understand that every case is commercial, it starts with 27 CFR 72.11, commercial crimes defined. If you look at that very closely and you read it, you'll see that everything is basically a revenue crime. So what they're saying is the prosecutor said that you broke some type of statute or code, some regulatory infraction, and they want you to pay the taxes on the fine that they filed into the court. Because the prosecutor, what they do is they file what's called a bid bond. It's an SF-24 bid bond. And so they file that with the court with their complaint, which opens up a 1099-A with the IRS, where they pull money from your minor account at the Treasury Department to pre-fund the case. So when you understand trust law, that makes you the beneficiary. You, the lender, it makes the court flipped in courtroom, and they're presenting it to you as if you are one and the same as the debtor that owes a tax that is due. But then they try to tell you that you can't pay the taxes and that you just have to go to jail, right? And then when you're in jail, you find out very quickly that jail is actually a debt collector because you have to pay all the fines that are due, and they don't let you out of jail until the fines that are due are paid. But how are you supposed to pay if you're in jail and you can't make any money, and you gotta. But 27 CFR 72.11 is the core of what's going on. It's a commercial crime, and anything that's commercial, you have to have a remedy, and the court will never state the remedy. Right? You can question the judge all day long. What's the Sixth Amendment nature of the accusation? We don't care what the cause is. We can see the cause. We have the bill of particulars. We have the list of all the charges. That's fine. We don't care. Now you have to actually tell us the accounting so we can discharge the penalty sum. Okay, in the commercial realm, that will be called redeeming the penalty sum. So this is where they've gone down the courts in this sovereign citizen path of saying, oh, people are thinking redemption theory. It's just like, well, it's not a theory. It's actually hundreds of years old. Even under the Hobbs Act from the early 1900s, it was very clearly defined that you can discharge any type of commercial or criminal liability with a discharge bond. This isn't a new process, is what I'm trying to get at. It's hundreds of years old. People have been doing this in maritime admiralty jurisdiction for a very long time. And this is where the rules come from. So when you understand the commercial nature and you can discharge, now the question is how do you discharge? Okay, the process is using the same bonds that they're using. So they already threw in the SF-24 bid bond. The GSA, or General Services Administration, the Treasury Department, they fill out the payment performance bond on their side, and they basically bond up the case, which is how you get a QSIP number for your case. And the QSIP is a tracking number for the securitization of the court paperwork. Okay, so that's all that means. It's just a tracking number. And so we can use that QSIP to prove that the case has been securitized and monetized. And that makes somebody the borrower, somebody the payer, somebody the debtor, somebody the creditor. You just have to flip the presumption of the court. So when you put in your own GSA bond, which is an SF-24, 25, 25A, 28, 1418, 273, 274, 275, and OF91, and they're filled out correctly, and you actually have standing to do that as a secured party creditor and holder in due course, because a debtor or a minor can't fill those out and can't use them, then you have the ability to discharge the entire commercial nature of the case and then come back around and file a tort claim.
No, I've been tracking along and showcasing for the audience here the meat and the content of the tort claim that you yourself have filed on behalf of
file torts to send a clear message to the courts. Prosecutor and the clerk of the court under the bus every single time to save their ass, which is kind of ironic because they're the ones that are supposed to be your trustee and a fiduciary and your administrator to do the accounting, and they won't do it for you because they understand as soon as they expose that the case is all about accounting and the IRS processes, then they assume a lot of liability, right? And they would rather see you in jail than to give you remedy. Because you're very, very dangerous to them, because their thought process is that if this guy can go around and just break laws at will and discharge, then he can go out there and just be a tyrant in society. And no, that's not the intent of doing this. It's about staying in honor in the court and not in dishonor, and not paying the taxes that are due. Your intent when you go through this process is not to be a lawbreaker. The intent is, if you accidentally break a law, that you say, okay, I accept your presentment. I broke these statutes and codes over here. I will make sure that the debtor that broke the statutes and codes discharges it. So you see the difference. You're not out there trying to like break laws and be a problem in society. You're saying that, okay, there's millions and millions of laws out there. There's no way I can possibly know all of them and comply with all of them on a daily basis. But if I accidentally do break one of them, I will be happy to make sure the taxes are paid. So there is a very, very famous case law behind this. It's called Black Diamond versus Robert Stewart and Sons, which deals with all four law form jurisdictions at one time. It deals with law, equity, admiralty, maritime. And so under admiralty rules 51, 52, and 53, when you deposit your bond into the case to discharge it, the nature of the case flips. So it flips from in rem which is against you as a natural person. This is how they're getting in rem jurisdiction against you, right? As a natural person. It flips from in rem to in res, and in res means against the trust or the object. Okay, so that means basically like your birth certificate. It means your discharge account that the custodian controls on your behalf, or your Treasury direct account, which we open as part of our SPCHDC process. We actually get the real legacy gold trust open, not the fake bonds and I bonds that everybody talks about on YouTube and TikTok and all these other social media platforms. There's only a handful of us that can get the legacy gold trust open in the United States and get it open correctly, where we can verify that it's open and have access to the black terminals to see that it's open and the transactions that are going on. Okay. So that's the case right there. It's Black Diamond versus Robert Stewart and Sons. That's what flips everything from criminal to commercial discharge. This is actually well known. It's actually used quite extensively in doing like a habeas corpus filing. The problem that we're running into now is even the federal courts where you file your habeas corpus don't want to acknowledge that this has been the standard procedure for habeas corpus for 40 years. They're basically, the courts are coming after you now, is what I'm trying to say. They're denying remedy at this point. So it's getting to the point where we have to take extreme measures against them to get remedy. And when you start to take these extreme measures, they're way that they're dealing with that is they're now saying that you're insane, and they will send you to a, and there's lots of people out there, and I know one of them is Yusuf L. He has a pretty popular like YouTube channel. They did this to him as well, and this is one of the reasons why he does what he does on a public forum, so they don't bother him anymore. But they will basically send you to a state hospital and they will drug you. Right? They will attempt to kill you with lethal injections of psychiatric medication, which is what they tried to do to me, except I survived. Right? I was actually in the hospital for a year paralyzed. As soon as they figured out what they did to me at the hospital, because they transferred me to like a regular, like a UC medical center. As soon as they figured it out, they're just like, holy shit. It's like, you should be dead right now. There's like, nobody survives this.
That's absolutely powerful and compelling and speaks to just how big of a threat the paperwork and the basis of education that you and your team have been engaged in really truly is. And I'd like for, if you don't mind, just for a moment, because this has just been an avalanche of information. I'm in fact still processing a lot of it. But with respect to a claim of tort, and with the document that I just showed a great deal of, first 20 or 25 pages or so to my audience, what is a claim of tort and why is it effective as a weapon at this stage in the game?
Okay. So when you understand that the whole process is a commercial transaction, who's going to pay the taxes? Once you drop that bond into the court, the entire case is discharged, and they're supposed to change jurisdictions into the court, into equity, and they're supposed to do all the accounting and do the discharge and let you go. Because at that point, you've basically proven to them that they don't have jurisdiction in the court. Okay, Federal Rules of Civil Procedure, Rule 12b2, they no longer have personal or in rem jurisdiction against you, because jurisdiction is flipped to in res, which is the bond that you dropped in the court for discharge. And so that's essentially like Title 48 Code of Federal Regulations. So that's bonding and underwriting. Okay, because the entire process is about bonding and underwriting. Everything in this country is bonding and underwriting. And the CSIG treaty, which currently runs our entire U.S. monetary system behind the UN and the IMF. So I kind of have to laugh when people watch, Tom Cruise in the Mission Impossible movies, and he's trying to find the IMF. I'm just like, they're wide out in the open. It's the CSIG treaty. That's what it's all about, money, right? Because remember, they're trying to hunt down money all the time, and who's transferring money and power. So it's kind of ironic that they do these movies, but that's what it comes down to, is the fact that you flip the presumption of the court of jurisdiction against you or your fiction, and now you've taken yourself out of the equation under Rule 12b2, and they can't admit it. Because the reality is once you challenge jurisdiction under 12b2 and the deposit of bonds for discharge, they have no case law on the other side to combat that. Absolutely none. So the cases that you've seen in the tort claim there would have been used for the last 77 years because they can't be beaten. Right. So once jurisdiction is challenged, the entire process is what's called abated. It has to come to a complete stop, and they can't move forward. But the courts are getting to the point now where they're claiming they don't understand jurisdiction challenges. Right. They think they just try to keep moving forward, not realizing that what they're doing is they're creating more and more tort claims against them. So the tort claim ultimately gets calculated under a very famous case. It's called Trezevant versus City of Tampa. This is where the government decided how much the tort claims should be calculated at. So once you discharge the case with your bond, it's $25,000 for every 23 minutes in custody. So you can imagine my tort claim, 3 years. It's $3.8 billion, isn't it? Okay, just for kidnapping and unlawful incarceration. And then you start racking up under 18 USC 3571, which is the civil side, because even though these people are committing federal felonies where they should be going to jail for what they're doing and spending the rest of their life in shackles in prison, can't hit them with that because they've given themselves sovereign immunity with their own statutes and codes. So sometimes that's why I laugh. I'm just like, they called us sovereign citizens. When I laugh at them and I say, you're a sovereign citizen because you wrote codes that say you're not liable for any damage that you create and the laws don't apply to you. That means you're a sovereign citizen. I'm here staying in honor in the commercial realm and you're denying me honor, right? You're in dishonor, right? They completely have no idea what they're doing or why, and they're intentionally mistrained. Even the bar members are intentionally mistrained in this realm. So that's an interesting issue when you're dealing with jurisdictional challenges. As soon as you go after 12b2, no personal jurisdiction, everything kind of crumbles for them. And especially once you discharge, now they have no commercial jurisdiction against you because you flip from in rem to in res. So against you to against now the payment, the commercial discharge. So commercial discharge actually falls under a couple of interesting statutes. It's basically Title 48, CFR section chapter 1, section 53-228. Everybody can go look those up. I gave you the SF bond numbers for that earlier. And then the discharge happens under 41 CFR 105-55-030. That's where the discharge process happens, right? And remember, CFRs means Code of Federal Regulations, which means this is the procedure, the operating procedure. Everybody has to follow it. Nobody can say no. But our government's constantly trying to say they don't have to follow Congress's CFRs. That's false, completely false. And then since this all falls under the IRS, then you look towards discharge under 26 USC 6325, which is the discharge statute for the commercial nature of the case under 27 CFR 72.11. So the irony is the IRS is hiding in a bunch of different statutes. They're hiding under Title 26 and they're hiding under Title 27, right? So it's very, very difficult to ascertain, what to do and what the remedy is and how to deal with it. But usually what we end up doing is if they don't let somebody go, then we file this tort claim. It's coming one way or the other. Now, if they let you go and they dismiss the case, usually what I will tell our clients is I'll say, run, right? Don't break any more laws, run, get out, leave them alone, right? They let you go, be happy. In extreme cases where they continue to harass people, we will say, okay, now you need to make the decision. Do you want to file the tort claim and put them in their place so they never bother you ever again? Because you're not a intentional law breaker, right? You just happen to have broke a law by accident and they're trying to do dumb stuff to you, like put you in prison for the rest of your life for absolutely nothing. Because that's what their intent is. Because when you're in prison, they start lighting up bonds behind your estate to pay for everything. So even when I was had already discharged and they had me in custody, they opened up 59 more bonds while I was in custody. We don't know what for, but they took hundreds of millions of dollars from my legacy account from that. And I have all the accounting for it. I have all the bonds for it. And those now become tort claims. So each one of those bonds is a $250,000 tort claim for a felony under 18 USC 2073 and SEC 10b5 violation, accounting and securities fraud. So you can probably see in the tort claim there, it just becomes a calculation. How many crimes did they commit times the number of people? And so the funny thing is, when I was in custody, once they figured out that I was actually a secured party holder in due course, and technically the government has labeled me as an internationally protected person under 18 U.S.C. 112, Public Law 94, 467, and 92, 539, the sheriffs freaked out because I started asking every time one of them came through the module. I said, I am filling out this complaint form for kidnapping and false imprisonment. I need your name and your badge number for the tort claim. And they freaked out, and all of a sudden nobody wanted to come into our module because they knew they were going to be signing their career away if they talked to me. So they literally had like this policy that nobody could talk to me, which was kind of funny. And the irony is, it was kind of fun because as I went back and forth to court, I never went in the bus. They never put handcuffs on me. They actually brought a special squad car just for me with 2 deputies, and they were very nice, believe me. We had normal conversations, but no handcuffs, air conditioning. I got my own separate cell to sit in while we were waiting for hearings and stuff like that, because the sheriffs knew what their liability was, right? And they knew that I was coming because they could see all the paperwork being filed. So in the days of COVID, we actually didn't go into court. We actually went to like a special holding room that had like video conferencing and stuff like that. And it was really funny because I would sit there and everybody else is handcuffed, but I'd be sitting there, no handcuffs. And they'd be
So
like,
the
"Do you want?"
illegitimate regime actually arrested you.
Yeah. Yeah, and they're the ones that arrested me, so they knew that I was going to come for them, and I was sending nasty grams to the sheriff at that time, saying, "Hey, you already know I'm a secured party creditor holder in due course. What do you think you're doing? You better get your bonding and underwriting ready because I'm coming." Right? Obviously, no response to any letters like that. And of course, I'm pro per in the courtroom. By the way, it took forever to get pro per, because as soon as they find out what you are, they immediately try to throw a public defender onto you. So then it's an admission to the jurisdiction of the court. You become pro se instead of pro per.
Which is
So pro per
tantamount to
means
incompetence.
yes, they're trying to say that you're incompetent. And they do all kinds of like crazy stuff to you. And you just sit back and you kind of laugh because you know what they're doing, right? And what they're attempting to do. So, then I have to take extreme measures like, file lawsuits against the public defender for, private trespass against my estate, filing tort claims against him. And he's a part of the tort claim now as a result of all the nonsense that he pulled. But you can imagine me sitting there in the video conference room. They leave my door cracked open, and there's 25 deputies standing around the door listening. And then after the video conference session it was kind of funny, was over, they'd all come in the room and we'd sit down and we'd have a discussion for about an hour about what just happened, because they wanted to know. Right? They wanted to know what was
Absolutely
going on,
remarkable.
because it's something they hadn't seen before. Because the reality is, while I was in custody, I got 12 people out. Instead of going to prison, they went home to their girlfriends and their wives and to their children. Right? So there are mechanisms to get people out. I understood that they weren't really happy with me, because I got feedback from people that were in court, and they were saying, "Did Mr. Duell help you with these pleadings?" And they were just like, "Yes." And I was just like, "Oh, you weren't supposed to tell them that." But all of a sudden the judge is just like, rah, rah, rah. You could tell that the way that I did their pleadings for them, where I accepted the presentment and then refused them to go to prison on behalf of the fiction. The judge didn't have any choice but to let him go. So
That's absolutely incredible, Todd. So we, the people, really do have tools, judicial remedy, but under different formatting than we've ever been taught.
yes, the remedy is pretty extreme, where you have to get to the point where once they let you out, you got to roll with those tort claims quick. You have a limited. Now, the interesting thing is, under jurisdictional rules, you can challenge jurisdiction at any time. There's no statute of limitations on jurisdictional challenges, especially in the commercial realm. When you discharge, you can challenge at any time. So this is the part that they don't like, is when you come back against them, where we have people come back like 20 years, 25 years later and file the jurisdictional challenges. They get really upset because they think that you were time barred. on the civil side, and you aren't, because the case law says that you're not time barred for discharge. Right? So they get really, really upset when you come back against them, because they think they're going to keep you long enough to the point where you can't file the civil claims against them anymore, but that's untrue. So if necessary, you just roll through as many courts as necessary, and you go to the Court of International Trade, where they will issue remedy, because a special master will be assigned, and they'll finally do the accounting, and you win. But the problem is getting there. It takes a couple of years to get there. You're looking at $100,000 in filing fees and petitions and pleadings and stuff like that. It's not a cheap route to get there. Let me tell you, it's not cheap, not free. But we're to the point now where we've actually digressed back to what we had to do like 25 years ago, where we're basically filing a Title 48 hearing, demanding that they do the accounting. And we're actually hoping that the judges strike Title 48 for bonding and underwriting, and strike the CSIG treaty for the United States monetary system, because now we can absolutely go after them. We can arrest and attach their bar bonds in admiralty maritime jurisdiction. So we go after them in their own jurisdiction. We arrest them in REM, just like they arrested you in REM. And we don't go after them personally, we go after their bar bonds. So we attach their bar bonds to pay the commercial liabilities that are due. And we basically get them fired as public defenders, as prosecutors, as private bar attorneys. We get them fired because they are not bondable. And for them to represent minors in the courtroom, which is what they're representing you if you haven't converted to a secured party holder in due course, they can only represent minors because they're bonded. Right? Because they're bonded for the commercial liability that they're putting you under and not doing discharge. So once we wipe out their bond, and the bonding company sees that they're being lit up for securities fraud, for SEC 10b5 violation, they will never be bondable ever again as a bar attorney. They will be out of work. They will have to seek a new career. So this is what we had to do like 25 years ago to get the message across. And we unfortunately have a new crop of people that are out there, judges and bar attorneys, that don't know this. And so we're basically having to take extreme measures to go after them, to retrain them, that when somebody does a discharge of a commercial claim, that they have to honor it, right? Because you do have remedy. But the problem is they don't understand what remedy is. And as soon as you're doing what I'm doing, you are decades ahead of their learning curve. I don't care if they've been operating for 10, 15, 20 years, even on the federal level, they're incompetent. They haven't studied. They don't know what they're doing. They don't understand Title 28. They don't understand Title 18. They don't understand that this is all run by the IRS. They don't understand that you have a remedy. They don't know who the trustee is. These people are literally like some of the dumbest people on the planet, with highly educated, allegedly, with at least 7 years of college education. And I consider them to be incredibly incompetent.
Right? Todd,
Now, some of the attorneys that you do run into, the interesting thing is, I tell people is, if you're trying to go pro per and the judge is, desperately trying to get you to take a bar attorney, is you just ask the bar attorneys some basic questions. What was the Sixth Amendment nature of the accusation? I need you to tell me, and I need you to put it in writing. What law form jurisdiction is the court charging me under? Which of the four? Please explain this to me before I enter a plea. Right? And then you say, well, since I understand that this is a commercial transaction, will you do the GSA bonds for me so we can discharge this and I can be released and we can just move on with our lives? And no bar attorney will touch it. So that's one of the mechanisms that you can go into the court and say, well, Your Honor, I contacted like 3, 4, 5 different attorneys, and I asked them these basic questions, and none of them will represent me now. So clearly this is a problem. So I need you to answer these questions. Right? And then all of a sudden, if it's not like a super serious crime or whatever, the judge will likely, want to dismiss the case, because they know what you're after, which is the bonds and how to discharge them. And they know you're not going to stop, especially if you're out of custody. If you're in custody, they're going to do everything in their power to keep you in custody, like do dumb stuff like deny bail. for you didn't like injure a real person, they're going to deny bail to try to keep you in custody, make it incredibly difficult for you to get your way out without help from friends and family. Right. And so you can imagine then the courts now denying habeas corpus under standard habeas corpus 27 CFR 72.11 and Black Diamond, asking the federal courts to trustee to discharge for you. They don't want to do it now either. Right? They're doing everything in their power to put as many people in prison as possible. They are broke. They are insolvent. This is the only way they can make money, and they make a lot of it. And I will tell you point blank, in the trust world that I work in, because I work with commercial paper, I work with bonds and things of that nature. I actually do have some clients of mine that they do sell the prisoner debt bonds on the international bond market. And I ask them every now and then, I'm just like, how do you continue to sell prisoner bonds knowing that you're enslaving people? And the answer always comes back is, well, I have a family I have to feed, and these make a lot of money for our company. So I'll get fired if I don't sell these things, and then my family won't eat, and I'll lose my house, my car, my job. So it's kind of like an incestuous process that everybody is feeding off of it. And if anybody wants to give remedy, they're looking at getting fired and, getting thrown out of their house and divorced and all kinds of nasty things that come at them. So they typically don't have any morals and ethics in terms of what they want to do to you to save themselves.
Multi-dimensional slave system, self-reinforcing.
Yes.
What an incredible...
And by the way, the sheriffs, of course, they get a basis point. They usually get 10, 20, or 30 basis points for every case that's filed in the court. So they're absolutely encouraged to arrest as many people as possible. And yes, there's case law behind this, and I actually have it. Everybody has to remember that your police and your sheriff, they do not represent you. So when it says to serve and protect, that means the corporation, not you. You are private, they are public. Everybody's traversing, everybody's a minor, everybody's a debtor. Nobody really knows what they're doing. Everybody in society is essentially flailing and has no clue what's actually going on, except for the people that are trying to figure it out as quickly as possible.
For those patriots out there, Mr. Duell, that would like to learn more about this process, are they able to reach out to you and your team?
Yes. We always tell people the proper approach to take is understand public versus private. So we don't contract in the public under the Ashwander doctrine, that's where you get your constitutional rights from, by the way, because everybody's banging the drum on constitutional rights. The reality is you don't have any. The Constitution is for the U.S. government. It is not for you. And the way that they determine whether you have any rights under the Constitution is the case Ashwander versus Tennessee Valley Authority. So that's the Ashwander doctrine. There's a 7-rule test. And so you don't have any constitutional rights. And so we tell people what you have to understand is when you're accepting benefits and privileges from the government, you waive your constitutional rights automatically. And so what we teach people in the trust realm is you don't want to contract with yourself anymore in your name. You want to have your trust in place, your complex irrevocable trust, which is what I do. And then when you're contracting with your trust, you're taking yourself out of the loop, and your trust contracts for everything. And that's one of the phases to understand how to do banking and commerce properly and do asset protection properly. Because remember, the government believes that they own everything under Title 12. It's Section 411, 414 through there. They have a lien on everything because of the bankruptcy. So you don't own anything in this country. So as soon as you understand that and you do your asset protection and you put everything into a complex irrevocable trust, now you're legal title owner and manager of your assets. Your beneficiaries are equitable use. You split legal and equitable title where the government can't actually take any of your property from you. And if they do, you can tax the living shit out of these people. Let me tell you, it's fun when you start sending them 1099s. Either A, B, C, OID, miscellaneous income, whatever is appropriate. because then they have to pay the taxes on the property that they took, and you get your remedy by return to source from the IRS through your trust. So you essentially get money back for the property that they took. Because remember, when they take property under the Constitution, they have to give you compensation. So this is how we do it, is through the trust world, because they can't take property from an irrevocable trust. They can only take it from grantor living trust or from you if you're doing stuff behind your social security number, because that's all their property. And then most of the time people go down that route, they'll ask us to do their estate conversion for them. So we'll do their secured party holder in due course. We'll open their legacy account. We'll revoke and revest legal and equitable title. And then the IRS world opens up to you, where you can actually, when you do things like bank deposits and pay vendors at the end of the year, you actually get your remedy. This is literally the only legitimate route that we know into the minor account, where they'll let you access your minor account and get a return to source with a check from the Treasury Department when you file your taxes. Okay. So quite a bit different, right? Most people are trying to figure out how to not pay taxes, and we're just like, we're buying as much stuff as possible, because then we get to ask for a check back.
What an incredible...
Think about that. Wrap your brain around that one for a minute. How do you get your money back? Through the trust world, because everything's in the Cesta K Vi trust already. You just have to learn how to access it correctly. So all the people out there that are trying to do accepted for value and all that kind of stuff, and ABCOYDs, I kind of laugh. I'm just like, you're not getting remedy that way. And in fact, people are going to jail for that. They want you to use a trust. They're not obligated to tell you that. And for most of the people in my realm know that I've been pestered for many, many years to write a trust book on this, and that's in the works, and it'll be done by the end of this year.
I very much look forward to checking back in with you regarding that. Where can Patriots find you if they would like to learn more?
Well, they've got my name. You go to my LinkedIn page. You can find me on LinkedIn. That's the only public media where I have anything, because that's for my trust clients. And so that's all the stuff that my trust clients know and understand and have learned to operate as the trustees properly. So that's the best place to find a lot of this information. Now, the tort claim and stuff, the interesting thing is, that's only limitedly available until that case is sealed. I already have a default judgment, summary judgment against them. It's in court. And now we're doing the Title 48 hearing to wrap up everybody's bonds and put people out of business. So as soon as that's done, all of this will be sealed up, so won't be publicly available anymore. That's actually one of the rules of the game, is when you get your remedy, you have to seal it. So everybody always asks,
no one else
show us
can find
cases.
out.
Show us cases. I'm just like, they can't. They're sealed. That's part of the rules. They can't let people know how to do this, because then everybody would do it, and they do it correctly.
Powerful.
Yeah. Now, there is one really famous case that you can search the internet for this one. This one's still available. It's Public Law 114-31. Okay. The only place you can actually get a physical certified copy of this is you'd have to do the U.S. Legal Archives in Washington, D.C., and you have to get special permission to go into the room. You got to wear white gloves. Because private laws apply only to the people who got the remedy. And this is the Ridout and Stark family from 2016. They got their remedy, and Congress gave them the $38 billion special fund for them, managed by the Treasury Department. And they got all kinds of other remedies. The government admitted they didn't have jurisdiction over a natural person. They don't have to pay taxes for the rest of their lives. They've got a special account for them to do banking with the Treasury Department. They have a special trustee just for them. They got 1,500 acres of land anywhere they wanted. The government issued their land patent to them, so the government couldn't take their land again, like they did, which was the issue behind the case to begin with, is the people had their land patent and the government said no, or at least I should say the local government said no and tried to take their land. Put these people in prison for like 8 years, even though the government was breaking the law. And so they got the remedy. It took a while. We did assist them. It took a while to get them out, but they got their remedy, and it was a big one, $38 billion. That's the largest one that's gone through to date. And that's all based off the same calculations that I just told you, the same tort claim that you just saw It's all the same.
A turnkey system if we know what to do with it.
Yes. Yeah,
Mr.
the hard
Duell.
part is actually getting to your minor account, getting your treasury legacy gold trust open, so you actually have standing as a creditor, like real commercial standing on the international bond market. Technically, you already have standing as a sovereign creditor under guaranteed trust versus and parity versus the United States. You all have it. They just don't want to admit it because they still see you as a minor and a debtor because you haven't fixed your commercial standing with the IRS, Treasury, DTC, Securities and Exchange Commission, Commerce Department, DOD, state, federal government agencies. You haven't revoked and revested legal and equitable title. I mean, they've made it incredibly difficult to allow you to get remedy, even though they are trained extensively in law school that if there's a commercial claim, there has to be a remedy somewhere. Contracts have to have remedies. So when you're in your courts with them, they're basically saying, if you're in there pro per or even pro se for that matter, they're saying that you don't have a remedy and we're not going to give it to you because you're not a bar agent, you're not a bar actor. But as soon as you take a bar actor, you don't have remedy. It's absolute, you don't have it, because their only job is to probate your estate and to take as much money from the Treasury Department as possible. And believe me, I know plenty of attorneys that I've met over the years that once they figured out what they were really doing in the courtroom and the sham of the commercial bonding system in the courts, they quit. They turned in their bar certificate, and now they're basically on the other side of the fence fighting, saying we're going to expose the courts for what they're doing, right? Because they know at a very technical level how to write the pleadings and stuff like that, and what to file and when, and how to fight certain issues. So there are bar attorneys that have quit that are out there that are fighting. They're just really hard to find because they like their little fiefdom that they have where they can control everything. Because remember, everybody needs to know this. We do not have constitutional courts in the United States. The only one is in Pennsylvania. That is the only one. Okay. We have Article 1 administrative, legislative, commercial courts, right? There's no constitution in those courts, people. None. You can't use it in there. You have to use commercial remedies. And you start banging the drum on constitutional rights, you're going to get lit up for contempt, and they're going to put you in jail for a while.
A story that far too many patriots have contended with themselves.
Yes. And so once you understand what kind of court you're in, then you can actually flip the presumption in the court. But as soon as you do that, you are way, way, way too smart for them. And they get really scared really fast. And they're going to use their mechanisms that they train on to try to stop you at all costs. And that's the disgusting part of this entire endeavor, is that they're trying to stop you. Why? I have to ask that basic question. Why are we doing this to ourselves? Right? The system was set up to do commerce and to do discharge. And why aren't we just doing it? Because we would have so much less fight in society as a whole. All the different groups that are out there that are fighting the government, if they understood that it's about debtor-creditor relationship and about how and when and who discharges, we have no social problems at that point. Because everything's just handled quickly and easily. It's just accounting. Right? It's one of the rules of the game. There is no money. It's just accounting. Somebody has to do it. Somebody's in charge of those terminals and can move debits and credits. That's it. That's all we have. That's how it was designed.
And indeed, that's how we overcome it. Mr.
Yes,
Duell,
you overcome it with accounting. You literally overcome it with accounting and IRS. And if you need to, you get really nasty with them and start filing A, Bs, and Cs and dropping securities bombs onto them. And I'm not talking like physical bombs. I'm talking about like the IRS and the SEC showing up for securities fraud and investigating what they're doing to screw up the accounting systems at the Treasury Department.
Mr. Duell, for Patriots out there, I'm hoping that you'll have the opportunity to come back to the show and do another check-in with us. This has been one of the more in-depth, highly detailed, highly thorough discussions that we've had on QNP. I thank you very much for your time. And for the audience out there, this is SG Anon. I hope you've enjoyed our conversation, and I hope you've taken a lot from it. Feel free to reach out to Mr. Duell's LinkedIn. Links will be included in the description below this video. And I'll see all of you on air again soon. Thanks, everyone.
Thanks,
Bye-bye.
everyone.